I'm going to call the city council work session to order with roll call.
Mayor Van Gordon,
Here.
Councilor Weber, here, Councilor Mo,
Here.
Councilor Rodley, here, Councilor Blackwell, here, Councilor Doyle,
Here.
Councilor Pictionary.
Here. Thank you. Okay, we have 2 items for the work session tonight and a whole mile of items for the seat when we get to see them. So the first one's applicant interviews for Springfield representative on the LRAPA board. I don't know. Do you have anything else to add to that, AJ?
Not unless you have any questions. We're very excited.
So there's 2 interviews tonight. AJ made a copy of the questions. It's up to you guys. Do you want me to ask them all? We've done that sometimes, or do you each want to choose a question to ask?
Now that you're giving us a choice.
Oh, my
You get the
shoulder
big
hurts
bucks.
from, all right.
So our first interview is going to be James Hugo. He is virtual, so I am pulling him up.
Can you hear me?
We
Can
can.
you? Hello, everyone. How are you tonight?
James, can you hear us okay?
Yeah, I can hear you great.
Oh,
Can you
outstanding.
hear me though?
We can hear you, so we are ready to rock and roll.
All right.
So the plan for the evening, James, is I'm gonna ask all 7 questions. And then to get through your interview, and then we've got one more after you. So if you're ready to go, I'm gonna
right.
start asking the questions.
Sounds like a plan. I'm ready.
So why are you interested in serving on the LRAPA Board of Directors?
Well, I mean, the main reason is I care about the air we breathe. I'm really passionate about the environment, and I really care about this community. I care about my neighbors. I care about my family and my immediate family. I even care about all of you folks. Some of you I've never met before. But I really, that's the main reason.
Could you describe your professional or personal experience as it relates to your desire to become an LRAPA board member?
Well, I would say I've been considered a community scientist for the last 4 years, and I've been constantly the last 3 going to school at Purdue, trying to get this environmental policy and management bachelor's degree. And I spent a lot of my spare time monitoring the air. I've partaken in a couple air studies here locally, just basically having the devices and going throughout the community and then outside my neighborhood and just gathering data. And so I'm still continuing doing that. I'm not partaking in any actual study right now through any organization or university, but I'm attempting to get involved with the wildfire smoke department over at the University of Oregon. They just got a nice grant from the EPA to start studying wildfire smoke. And I'm just waiting for another email to get back from them. And then hopefully next year I'll start working with them. That's one of my goals. But yeah, I work with Beyond Toxics as well. They're a local nonprofit. I'm constantly up to date with what's going on at the federal level and at the state level. And I'd like to be involved here at the local level. So I think I could talk to you for hours about the science and the information that I'm learning every day, but I don't have that much time tonight, so I won't bore you with the details.
Could you please list any areas of concern you have about air quality, community development, or the environment in general?
Well, I would say the main concern that I have is there's not enough data. And so, I mean, I have other concerns regarding the environmental issues in Springfield. But the facts are that there's not enough facts. So hopefully in the future, we'll have enough data to actually know more about what we're being exposed to and if we're being exposed to, that's what I should say too. But yeah, the other concerns I have are there's a lot of factories and heavy industry in our community, not just Springfield, but throughout the whole county. But Springfield has a lot of it too. And I firmly believe that these companies and factories can exist and coexist within our communities if they are operating efficiently and 110%, up to date with what we have technological wise. Now, International Paper Corporation, owned by Weyerhaeuser Property, is one of my main concerns because they can coexist and operate if they do it right. And I'm hoping that they're starting to get there. I personally feel they've been taking their time to get to that point. And so that's what I think the main concern outside of not having enough information to study it and understand what's going on with what we're being exposed to. But I would just like to see things get a little bit more, like, basically have the businesses and the big corporations become good neighbors. That's my goal as an advocate and as an environmentalist, is to see that happen, not just here in Springfield, but throughout the country. So
Outside of the monthly LRAPA board meetings, what amount of time of volunteer time do you have to offer for working on with the LRAPA board?
I could probably commit to 10 to 15 hours a week, maybe 20 if that. I mean, I have a very flexible schedule. As long as I'm able and the board's willing to work with me. Like, I love Zoom. Zoom platform's amazing. I do have some goals to get, to be able to get to meetings and be able to be in person. So that's something that I'm open to, and I'm going to try my hardest to make that goal be a reality. But I'm very flexible. I like to serve. I feel like that's what I need to be doing. I can't seem to buy a house anywhere outside of Springfield. So we're here and we might as well make the best of it. And I'd like to get more involved.
Can you give us an example of your experience working on a committee?
I don't know if I've actually been on a committee. I've been on I've partaken in a lot of state government hearings and up at state level in Salem. I have experience being around meetings like that, and I've listened in on a lot of council meetings, but I honestly don't have any personal experience having that type of responsibility. So that's kind of why I'm excited to try to make this happen, because I would really like to try it and to see if I can do it. And I'll be the first person to say, hey, if I can't do it, I will raise my hand and be like, I can't do it. But I feel like this is something that I can do. I really feel like I can be a good attribute to this board and bring a lot of good ideas to the table and be a good community member.
Please name one way you help inform our community about LRAPA or LRAPA projects.
One way that I have, or one way that I would like to?
That you would like to.
Okay. I honestly think LRAPA would be, I don't know if they do this or not, but in schools, like elementary schools, middle schools, high schools, maybe even going to the University of Oregon and LCC. I mean, I think they actually have been at the U of O, but getting involved that way and like assemblies, and then of course social media is a powerful tool, and I think that would be a good tool. And then there's always old-fashioned radio, and there's podcasts all over the place. There's a local podcast called Spent the Rent. I would love to see. I don't know if Travis Knudsen has been on there. I think that would be a good. I don't know if Patrick Stutz would be even open to doing that, but it's just that coming to my mind. The first thing that comes to mind, thinking local. But I don't know, I think that's what I would stick with, those three ideas.
And finally, how do you think the work for the work of LRAPA will improve our community?
Better air quality, and more information, more science, more data. I think that's the best thing that LRAPA could do for the community is to keep us informed and just keep on doing what they're doing.
Perfect. That was my last question. Thank you, James. We're going to go to the next interview, and then somebody's going to be in contact with you with the result.
All right. Well, thank you for your time, and I hope you all have a wonderful night.
Thanks, you too.
you. Our next applicant is Kurt. If you'd like to come up and have a seat.
Hello.
Hello, Kurt. So,
I heard the question. That's a tough one to follow. He's got some qualifications. I certainly don't.
all right. Are you ready to work through this?
Sure.
All right. Why are you interested in serving on the LRAPA Board of Directors?
Like him, I'm concerned about the air quality and, but also, I've been thinking the past probably 10, 15 years, it'd be nice to get involved in government, involved in, working with, making decisions and working with the, the government in the city and even beyond if possible. I just think that, I'm just not very impressed with some of the leadership we have in not Springfield area. I've heard really good things about Springfield, but in Oregon overall, it seems like it's lacking some people with good decision-making skills. So that's, but yeah, I like him. I like to go out hiking. I like to have clean air. I like to do things outside. And so,
Yeah. So, could you describe your professional or personal experience as it relates to being an LRAPA board member?
I have none, he's got schooling and stuff. I have none of that. I've worked in a grocery store all my life, so that's what I do.
Could you please list any areas of concern you have about air quality, community development, and the environment in general?
I think that, like he said, the factories and stuff like that, it'd be nice to make sure that they're held accountable, that there's an oversight, that, anything they're putting into the air is tested and we're making sure that it's as clean as it can possibly be. Oversight mainly. I think there needs to be good oversight on.
Outside of the monthly LRAPA board meetings, what amount of volunteer time would you have to offer LRAPA?
I am retired, so I have a lot of time that I can put into it if need be. If I'm given a call and they said, hey, we're going to be doing this, it's important. Can you make it? I can drop what I have going on and do it. Other than if it's something important with my grandkids, I'm not dropping that. I'll just say that right off the bat. That's priority.
Well, there's a couple of grandparents that are around this table that get that.
Yeah.
Can you give us an example of your experience working with the committee?
Government wise, none, but I was a manager at the store I worked at, and I was on many committees, wage committees, things like that, safety committees, a lot of safety committees throughout the years. I worked there 34 years. So I was probably on, I would say, a dozen committees over that 34-year period.
Please name one way that you would help inform our community about LRAPA or LRAPA projects.
Word of mouth. If it was really important information that I need to get out there, my pastor would be more than happy to talk about it from the pulpit and get it out there if it concerned the community. And I think he could probably talk with other pastors if it, you know, if it warranted. I believe that would be a good way.
And how do you think the work of their El Rapo board will improve our community?
Honestly, I don't know a whole lot about El Rapo. When I was approached and said, you know, there's going to be an opening, would you be interested in serving on it? I said yes, and I looked into it a little bit, but there's not a lot of information out there that, you know, that could tell me a lot. I don't.
Perfect. That was the last question.
Okay.
Thank you so much.
Yep.
So we're gonna deliberate. You can hang out. You can you know, go home, or you can do it. But somebody will be in contact with you
Okay.
about what the outcome is. Okay. Thank you.
Thank you.
Thank
Appreciate
you.
it.
Thanks for
All right. Yeah, thank you. Thank you. See you.
All right. So we've got to come to some sort of decision here about who's gonna fill the citizen role for El Rapo.
Is it something that we have to? Or if we don't want to pick one of the two that we
We
have
could
as
send,
candidates?
we could send it back out again if you wanted to. That is an option.
That would be my option. That would be my request.
I feel totally comfortable with James. I think he's been involved and passionate. It'd be nice to have that point of view on that board.
I can't hear you. I'm sorry.
I feel totally comfortable with James. He's been involved and passionate, and I think it'd be great to have that perspective on the board.
Victoria's go back out. Okay. Anybody else? Joe?
Yeah, I think that's probably a good choice, is to go back out and make sure we have a good pool.
Yeah, I agree. I would like to see if we can get a little more interest and have a few more candidates to talk to.
Or you go back out?
Yeah.
Okay. You go back out, or do you have a choice?
I feel like maybe go back out as well.
Okay. So,
I'm kind of torn on this one, honestly. No, I think James is really passionate and that has, you know, a lot of passion and drive, but I feel like I'm not quite sure if he's right person for it.
okay. So, let's do this, go back out, and then can you see if you can't squeeze it in on one of the first meetings we get back, because El Rapo is gonna, by the end of the summer, is gonna be knocking on my door going, where's the person?
Absolutely.
I didn't even know that we were filling this position. Otherwise, I might have reached out to people to apply to.
Yeah,
How soon does that have to be built?
Well, it sooner opposed to later, El Rapo will be fine going one person down, but like there's no deadline and we've got to get it done in.
I can do a little background.
Sure, go ahead.
So yeah, what happened was we lost our last one. He passed away. And so that was unexpected. He didn't survive a surgery. So, but in Rapa, Springfield only is allowed one citizen representative on the board. Eugene is allowed 3. And so it's really a matter of trying to keep some balance. Oak Ridge has 1, et cetera, but so there it's whenever any one of them, even if it's Eugene representative or whoever, if there's someone missing, it is really, you can really feel it in that board of directors. So it's pretty important to not have any openings in that particular committee. Kind of, it's almost similar to like this Springfield, the Police Advisory Committee is fairly, each one represents a big chunk. But they need the person, so I think going back out and giving everybody a chance to recruit too would be good.
Okay. So the next item is code enforcement administrative civil penalties, and Charlie Kent is back.
Good evening. Interesting to see how the sausage is made sometimes. We'll be going through our own interview process here at the end of June. Thank you. So it'd be good to get somebody on board.
Charlie, what position was, is that for another code enforcement officer?
The replacement for Officer Bradley.
Okay,
So we'll be back to full strength in 2.
okay, good.
Okay, perfect. Thank you, Mayor Van Gordon and Council. Again, my name is Charlie Kent, and I'm the city's code enforcement officer. I appreciate your time and consideration tonight. We're here to discuss administrative civil penalties and their application as a tiered enforcement response within the code enforcement program. Before I begin with the ACPs, as they're known, however, I'd like to take a moment to kind of provide a broad timeline for rolling out our reconfigured program updates as they look currently. In January of 2024, we will be using a policy and procedure manual and operating with strategic goals. We'll also have a software update that we'll be doing this summer, which will also affect our workflow process, make that a little bit more efficient as well. And a big benefit that we'll get from that newer software is we'll be collecting a lot more analytical data, right? So we can make some business decisions based off of numbers and facts. And so it'll be a pretty fun time in the code enforcement program. So ACPs are an important foundational piece for this program in several regards. ACPs provide that tiered enforcement response to violations which don't require that full judicial process. The practical application of ACPs compel officers to get out of their trucks and make contact and engage more with community members. And they also provide a better mechanism to resolving those legal issues or those issues that are right in front of the officers right then. So I'd really like to come away from this session with your support of the administrative civil penalties process as that tiered enforcement response, which Council President Pictionary mentioned during our May 22 session. I would also like to hear from you regarding any policy or the Muni Code updates that will be required in order to use ACPs. So I'll start with a disclaimer. Neither of these photos are of homes in the city of Springfield. I Googled cars parked on the front lawn, and these are what popped up. So it's public information either way. And I'd also like to tell you a quick personal story to kind of frame this. So my daughter recently moved to Oklahoma City, and as she's moving in, the single car garage is full, and so she parks her car on the front lawn. And Oklahoma City's code enforcement team paid her a visit and wrote her a $100 citation right off the bat. She was really upset about it. $100 means a lot to a 20-year-old, but it was really that notice to correct. She didn't have, a corrective period with which to comply. She had no idea it was a rule, right? Most people don't. So it's important to consider or to understand that ACPs for us aren't just a ticket right off the bat, right? This is just a faster mechanism to get to voluntary compliance, which is our goal. Okay, and if you don't mind, I like to move around, but I'd like to point at the screen as well. Does that work for everybody? For the video? Okay.
You might get really close to it, but you'll be okay.
Okay. Okay, so the photo on the left, I'll try not to stand in front of the camera. So we've got prohibited parking, which is a nuisance code violation within the Springfield Municipal Code. Basically, it states that you can't park anywhere between the front of your house and the street except on the driveway. Okay. So if this were occurring in the city of Springfield, both of these homes would follow the same legal process, the same judicial process that we use. I'll get a little bit more into detail later, but this is a pretty timely process, and it's not quite appropriate for this instance, right? Administrative civil penalties could allow officers to attempt to resolve this right on site. If I were to pull up to this and come and knock on the front door, ask the responsible party or the homeowner to move their car. We're talking a 15 or 20-minute conversation, a little bit of education. Everybody's walking away smiling, right? Instead of that letter in the mail, which is probably a little bit better for this picture, right? So we've got several different violations. Prohibited parking, there's a vehicle parked outside of the driveway. There's a bunch of stuff, and I apologize about the quality of the photo. But there's a bunch of stuff stored in the back of the vehicle, which is a violation of the code. We can't quite see the silver car, but it's leaning up on one tire, which indicates that there's probably some support under there. So there's some mechanical work going on. The hood is up. There's another car parked on halfway on the grass, halfway on the curb. Not sure what's going on there. And then another vehicle parked parallel to the one parked at the curb. So potentially we've got 4 municipal code violations, not including the potential of a party bus or a commercial bus that could either be parked next door. And then another development code violation of an accessory structure too close to property lines. Okay, so in essence, we resolve these the same today. We could make that a little bit different, right? We could do that a little bit better. Okay.
Hey, Charlie, please ask some questions.
I just think it's a kind of a good time to cover this because it's a major concern that I have had for a long time, is that you're referring to the homeowner here, easy contact, no problem. And then over here, but what happens is there's a such thing called rental homes and the renters. And renters aren't getting cited. It's the property owner. So their landlords are the ones that are under the gun in regards to liens on their property or assessments against their property, when in fact it's the renter behavior that is violating the code. So there's in code, there's no separation or contemplation in regards to whose behavior is causing the code violation, as opposed to who's going to have to pay, should there be a default. And what happens currently is that the default now gets assessed against the property owner, i.e. the landlord. And of course, the landlord says, hey, people tell the landlord, well, I'm sure you can't break the law because that's against a contract, a rental contract, which is common. But then the renters are protected from any type of kick-out orders, typically without a prolonged process, if at all possible. So in the middle of renter behavior and the property owner, ultimately the property owner is the one that's caught holding the bill. How are we going to eliminate that?
Well, I can tell you firsthand that there's a typical process that I work through when determining a responsible person. I take the shortest avenue to correction, who is directly responsible and on site and able to correct this issue, right? The person on the left, that's going to be pretty quick and easy. Person on the right, it could be a renter, as you say, or it could be a homeowner. Both of which you start at the bottom and work your way to the top, right? In terms of corrective action, the notices that we administer, that I send out to folks, are administered to, or excuse me, addressed to a resident of the property. I can get the license plate information. I can find out who the registered owner is, address them as well. And then our lid collects the property owner information, so they're notified through all 3 phases. It's been my experience that when I address these violations through the residents or the renters, if you will, probably less likely to correct them than a landlord would be. However, there's a significant amount of time between that initial contact of the notice to comply, or that initial notice of violation, and you'll see it a little bit later, to 60 days when the landlord, we're trying to give them the opportunity. Now, even then, after that final warning citation, it's not always a civil citation directly to the landlord or the property owner. It's very often that I cite the responsible party, which is almost exclusively the renter in that sort of relationship.
So yeah, I understand the process and I've seen it and I've seen the letters and I've seen some responses and I've spoken to several different landlords that are upset about how current process is when they're being held to a standard, an understandable standard. It's not like they aren't okay with the code. It is the enforcement process and there doesn't seem to be a clear, you know, you're referring to sometimes this and sometimes that, and I get that, but it should actually be very clear if there's a violation based on a particular person's behavior, then that person or persons should be held liable for that and that's not the property owner, so to speak, if it's a rental situation. And it's easy to use cars as an example. But there's many other code violations that have occurred out there that result in the landlord getting penalized and being taken to court and having to defend themselves with attorneys in court to not be held accountable for those or attempt to not be held accountable for those code violations. I'm just wondering if there's equal amount of consideration. If we're changing this up, it seems like this is a prime opportunity in which to look at where can we change that process so we're not hammering landlords based on renter behavior.
You know, I don't know if I have a great answer for you.
I don't expect you should have to. I'm just bringing that up. So I think this is a perfect time to just, if we're going to go through this whole shebang, I think this is a perfect opportunity to not let this part go unaddressed.
Yeah, let me look back into it and I will chat with Mary Bridget.
The one thing I see this ACP process is decision when staff will be given discretion to negotiate. There's some flexibility with them. I like that.
Yeah, thank you.
I just want to echo, I think that's a critical distinction Joe brings up, right? Like because we're redoing the whole program essentially, right? And I know you guys have to sort of work and hammer away and figure out what you're going to do, but sort of creating the right amount of tracks so that, you know, so that you can engage with people the right way would be helpful. Victoria?
I'm also a little confused that someone parking on their own property with a car would be equal to somebody blocking the sidewalk so that a person in a wheelchair has to go out into the street. I know that we're dealing with a lot of new neighborhoods now where the driveways are very short. And I have one new subdivision around my house, and when I walk my dog, literally every other house has a truck sticking out into the sidewalk, and I have to walk around them. So I just find it difficult to believe that someone who's parking on their own property with their working vehicle is held to the same standard as somebody who's doing something that's clearly affecting other people in our community versus just being kind of an eyesore.
Sure, and there's two violations to be clear. Parking entirely on your own property is just prohibited parking. If you're halfway on the sidewalk and halfway on the front yard, that would be both obstruction of right of way and prohibited parking.
But why is that? And why is that a violation to park on your own property?
That was determined by
Okay.
council when we wrote the code.
Okay.
It's in the muni code. And so I think Charlie's mentioned there will be municipal code changes required to implement this new process. So it may be an opportunity the council may want to consider, do we want that to be a violation in Springfield any longer?
No,
I
I
mean-
don't want to see my neighbors all putting cars up on blocks.
Right, so I mean, it's
Like
something
the
to think
comparison of the two, you know,
Yeah.
one's affecting them and one's affecting.
Steve?
Mr. Russ knows that with the new laws coming, there's gonna be a lot of parking problems out there. And we can address them. For everybody, I don't have any voice today, I'm sorry, but it's gonna be a big deal. And the intent is to get cars up off streets or not off the streets, just gone. But in the meantime, we have that.
Yeah, and Councilor Mo's referring to the CFAC rules, the climate friendly equitable communities rules, that we will no longer be able to require parking anywhere in the city as of the first of next calendar year. And we already see it, and I'll just use Marcola Meadows as an example. Our fire department's having problems getting their fire trucks through that neighborhood. It's brand new, you know, everything's pretty new and nice, but the parking, and they've provided parking in Marcola Meadows in accordance with our code today. So anyway, it's gonna get worse.
Yeah.
For sure.
So well, we're talking about parking, right? Like when you play this out in the future past 2024, right? Like, and you think about Marcola Meadows and assuming that nobody provided parking, like it is foreseeable that our streets really could look like Marcola Meadows where we're having trouble getting fire trucks in, right?
Yeah, I would,
So what's the remediation to that? Is it,
Well, enforcement for one, but not that Charlie does parking enforcement, but, and I'm sure the police doesn't want to do parking enforcement or doesn't necessarily have the resources to do it, but it may be rethinking our street designs. You know, we narrowed a lot of our street cross sections. Is that still appropriate? Should we allow people to not have parking on their streets if we know there is going to be a demand for it and it's likely to happen anyway? I mean, I don't know. These are large policy level discussions for you to consider in the future, probably.
as usual, code enforcement touches everything. All right, Michelle.
yeah, I would just like to talk about on street parking as well. Almost every access into my neighborhood now is parking on both sides of the street. It's a real challenge for us as cars to navigate, but fire and emergency, that they're really, you know, it's a tight squeeze for those guys. So I would really like to have that conversation too.
So as you can see, violations are occurring in both photographs. Basically, what I'm trying to get across is that we probably need to have two mechanisms for enforcement so that we can address both problems to their best resolution. Really talking about is how the code enforcement program can be more effective. This is a small piece of it, but to be more effective, we need to identify and develop more tools in our toolbox. To frame this, try and think of the administrative penalties process as a parking ticket or a fix-it ticket. The violations are simple to correct and the fines are relatively low. Now think of the civil citation issued in the judicial process as more of a Dewey citation, a driving while under the influence or intoxicants. This is the fines are significantly higher here, and the procedure to citation involves many more steps. There are two differences between a judicial and administrative civil enforcement process: presumption and procedure. Excuse me. In the civil citation and complaint process, the city presents facts and testimony to the municipal court judge, who then finds the accused guilty or not guilty based on the judicial interpretation of the code, those facts presented, and also by both the city and the accused during the legal proceeding. If found guilty, the city recommends an appropriate penalty, but ultimately it's the judge who makes the determination of both the fine and of guilt. In the administrative civil penalties process, it is assumed or presumed that the city's findings are factual. There's no judicial intervention or determination made. Penalties are unilaterally imposed through a standard violation specific matrix. And because due process is required for lawful applications of both processes, an appeal process is available in both. And we'll get into that just a little bit later as well. Currently, with the limited data collection system that we've developed over the past 6 months, we've received 179 complaints. Approximately 100 of those would fall under the umbrella of the ACP process through that first inspection. It could transition to a different process if, for instance, we get a report of a car parked in a prohibited area, and we show up and there's, they're running a auto mechanic shop out of their backyard. That's going to be a different avenue to approach.
So out of those 179 sort of reports, right, how many are you getting through right now? Like you're saying roughly over a half could go into this ACP process, but with only 1 or 2 people doing the more complex process, what's your ability to get through that 179?
The goal, if I were to work without administrative outside of an administrative capacity, I'm just on the streets. The target goal is to touch about 10 cases per day. Phone calls, complaints, inspections, and then rotate through that 50 through the week. So at any one point, I'd be closing some, I'd be opening some, I'd be responding and processing those.
See, 179 isn't, but what time period?
From January 1.
Okay.
of this year.
All right.
So for those 100 complaints, the ACP process would be a good candidate as that first response. It's more appropriate. It's a more appropriate response to those larger volume complaints, which are a single violation or have a low barrier to compliance. So think of, you know, a basketball pole that's just stored in the street as an obstruction of right of way, or maybe you have a couch by the curb which has a sign free posted on it. Those are small potatoes.
Curb alerts.
What's that?
They're called curb alerts.
ACP also provides officers to make officers an opportunity to make those community connections. It allows us to engage and get out of our trucks, as I said before, and knock on those doors and really approach enforcement through an educational lens, at least during that initial contact. There's also potentially a much faster resolution time because of the short time frame set for initial compliance. When someone has to pay a fine within 3 days, they can see that financial implication much quicker than the 30, 40, 60 days for a nuisance violation. Additionally, the ACP process can also serve as a precursor to the judicial process by fulfilling the required prior warning section of the municipal code. Currently, it's codified that the city shall make a contact and warn somebody of a violation before issuing a civil citation. This process, the ACP process, would fill that role. We'd be able to roll right into a civil citation if necessary. And that's not to say that the judicial process doesn't have its place within the program. It really does. In some instances, the judicial process works well in conjunction with high barrier to compliance violations, right? So if there's a lot of required corrections, for instance, you have 4 municipal code violations and 2 development code violations, we're going to attack that piecemeal and try and work with those responsible parties to voluntarily comply and put some structure around it so that it's a little bit easier to swallow. Right. We might address, 3 nuisance violations or one portion of the entire issue within a given time frame, and then readjust and progress from there. Additionally, there are financial constraints and sometimes parallel legal processes. Councillor Pishner, you spoke about eviction and oftentimes with those chronic or those real tough renters, there are additional legal tools that landlords use to resolve the issues before receiving a citation. And the municipal court process also insulates staff a little bit. We're not the final determination of whether or not the party is found guilty. It provides for an alternative method for folks to be heard in a legal format. And also for those chronic violations which require post-citation legal processes like an administrative search warrant or an abatement warrant. It allows the court to get ahead of those a little bit so they're not too surprised about when things come up. So the ACP process, as I envisioned, would have a predefined matrix for the city's response to common or low barrier violations. Initially, I would focus on these top 3 municipal code violations: prohibited parking, garbage stored in the public view, and obstructions of the right of way. Now, I've explained prohibited parking. It's basically parking on your lawn on either side of your driveway and between the street and the face of the house. It's against the code to store garbage in public view if it's not within a wholly enclosed leak-proof receptacle with a lid and then it must be removed from property once every 7 days. That's what the code states. Additionally, it's unlawful for any person to prevent public passage or free passage over a public right of way as well. And so the required corrections for these violations are simple to correct, they're simple to manage, and they're simple to address. Because this is a potentially new process for the code enforcement program, I think it's prudent to start with three easy to administer violations initially, and then build out into other violations as needed. Especially after we refine the administrative aspect of the ACPs. One thing about the ACPs is that we'll have to use administrative staff in-house to collect those fines and develop that as well. So that will be included with the software as that goes.
Victoria?
Quick question on the fences. Does the city of Springfield have a irrevocable petition process so that if somebody has a fence that they have built that or like a retaining wall or something like that that is intruding in the right of way, that they get something that covers that says, look, we know you've got this here, but if we ever need you to move it, you have to move it, but they're sort of covered so they're not repeatedly getting bothered by that. I just didn't know if that's something that we have.
We do have it a lot of times for new ones, especially retaining walls.
Okay.
And Jeff might know a little bit more about from the engineering side when it's in the right of way, but it's part of the yard or just behind the sidewalk, that kind of thing. Fences, not so much probably, but we do operate on a complaint basis. If the fence is causing an issue, that's when it would be addressed.
All right.
I just wanted to interject something really quick, and that is Charlie said a lot of these low-hanging fruit kind of violations are easy to resolve. Sometimes they're not for people. You know, the trash might build up because there's, you know, it could be movement concerns or just financial concerns. I also want to put a plug for Charlie does a really good job with also connecting people to resources that are available in the community. We do have a grant right now we're working on to provide free trash for disposal for people, dumpsters and things. So anyway, there's a lot of that work that goes on that Charlie's probably not going to take credit for, but it's really working the entire problem from a holistic perspective, because some of these things might seem like they should be easy, but they're not always. So.
Right. So due process, and I've told you I'd come back to it. And it's important, it's very important to note that people have rights to due process. I don't mean to sound presumptuous, but when you hear due process, I get lost because there's a few different aspects of it. And what I'm really talking about is fair procedures. So when you think of due process, think of fair procedures. And another way to explain it is that due process means that a citizen who will be affected by a government decision must be given advance notice of what the government plans to do, and then also how the government's actions may deprive them. Right. So within the context of code enforcement, one aspect of due process is the right to appeal the decision. So within the current civil citation model, an appeal is made to the circuit court. The appeal must be made within 30 days following the court's decision. And the city is represented then by the city attorney's office, and the petitioner must represent themselves in circuit court. This is a formal legal process with a circuit court judge presiding, and it's appropriate sometimes. I've never been involved in an appeal process through the city, but I've heard it's pretty daunting.
Joe, Charlie, you're referring to cases that are adjudicated in our municipal court, and the respondent wants to appeal that decision and goes to a higher court.
That's right, Councilor Commissioner. Thank you for clarifying. So the municipal court judge would render a finding of guilty, and then that appeal would not be made at the municipal court, but to the higher court, the circuit court.
Automatically circuit court.
Right. In the ACP model, there's the same right to be heard. It's a little bit less formal process, and it's done through a hearings official. A hearings official, the city has contract through LCOG, and we would piggyback off that. if we were to implement this. The appeal must be made within 10 days of the deadline for payment. And the legal environment is much less formal. It's a simpler process, and my understanding and experience is that it's been geared more towards mediation rather than finding. But regardless of the venue, a person's right to due process must be observed by the city. So our current judicial process, and to provide clarity in the difference between our current process and ACP's, I'd like to walk you through some common workflow steps that we use with days and just kind of a simple progression. Please keep in mind that code allows us to be pretty flexible with deadlines. So we can extend deadlines, we can, we're not going to shorten them, but we can always extend deadlines.
Yeah, reduce them.
So initially, the city receives a complaint. We receive a complaint from many different areas that comes into our administrative staff, who then creates a record in a cella. This inspection is scheduled, and this can take anywhere from 1 to 3 days. If it's a fire life safety issue, we usually respond same day, and there's been a few over the past couple of years where we've gotten out there pretty quick. But more typically, it's that 1 to 3 day administrative process, and that's going to be the same on the judicial side and also on the ACP side. Now, following that, or depending on the result of that first inspection, a notice of violation is mailed to, again, the responsible parties who the city finds. We look at license plates and property tax records. We try and contact neighbors, or maybe the complainant has that information. So we get as much information to determine that as we can. That notice contains all the legal required documentation of due process, plus a very clear outline of what the violation is, what the deadline is, and also what the required corrections are. What are we looking for you to do? And try and clear the outline that. The deadline is typically 30 days, depending on what the violations are or the quantity. And then the city then moves on to, once that notice is set, a re-inspection is set for, if the deadline is 30 days, then we're going 31. We'll be out there the day following the deadline for re-inspection. This process is repeated through the warning citation. That initial notification is a notice of violation. Second one is a warning citation. The third one is a final warning citation. Once the final warning citation's deadline has passed, the city then changes gears, and we issue a citation, a complaint and citation, and file that with the municipal court. Code officers schedule the arraignment date for 14 to 21 days following the date of the citation, which is typically the day of that last inspection. And then the accused then goes before the judge and enters their plea of guilty, not guilty, or they can plea in advance. There's a few different options there. Almost exclusively, they enter a plea of not guilty, which sets us over to trial. Trial occurs 21 to 30 days past that. I've seen it as long as 60, and also as short as probably 14, though that's very common, or not very common. Our potential time to the very first fine being placed on the responsible party is 60 days. More regularly, deadlines are included within these notices and warnings. We extend violations out to try and get some compliance, but 60 to 90 days is what we can expect from for that first fine to be implemented.
Is there interest in stuff that accrues if they don't pay?
No, not right now. One of the benefits of the ACP process is that it can be tailored to the city or community needs. A schedule or a fine matrix would need to be developed by the city and adopted prior to using the ACPs. I envision a progressive penalty matrix with a standard for those deadlines. So establishing, what's it realistically going to take to get your car off that front lawn and move forward from there. And then any re-inspections following the, those notices or those fix-it tickets would also be included in that standard schedule. During the first inspection, again, we're complaint to first inspection, 1 to 3 days. That's going to be a standard. Following that first inspection, here's where the big difference comes in. That's when we take a little bit of time on the scene. Instead of driving by and collecting a photograph, we attempt to make contact. Every reasonable attempt to make contact in person or resolve that violation on site. If unable to do so, we could potentially leave a notice to comply or the relevant educational materials on site in plain view in a mailbox or taped to a basketball pole if that's the issue, tucked under the windshield wiper on a front car, or excuse me, on the front windshield of the car. And the first notification would also set a much tighter timeline. So from that first notice, we would be out and set that deadline to be 3 to 5 days. You know, I mean, it doesn't require a lot of effort, and that's why we're really targeting these specific violations to really get the administrative process down, and then kind of roll out the others progressively. If the violation remains on site, or excuse me, if the violation remains on re-inspection, potentially we could issue a fix-it ticket. This would follow the same vein as the notice. It would be left on site if no contact was made. But again, every reasonable contact would be made in person. And it wouldn't be an immediate fine. We would request, or we would basically provide an order within 5 days. Either if this is still remaining, there's a $50 fine attached to it, but you also have the opportunity to correct that as well. Depending on the progression within that scale, I would like to set a ceiling to the limit of the fine amount. So I don't want to issue a $50 fine every 2 days for the next 3 months. Eventually, it would reach a kind of a critical mass, roughly $500, depending on how that, you know, that's a substantial amount of money. And it's also the maximum fine amount for your first guilty finding within court. So on every violation as we currently work, every violation that we cite into court potentially has a forfeiture of $500 for the first violation, and then $1,000 for every violation if within a year of a citation. I explained that enough. So your second citation is going to be, that's per violation. Oftentimes there's 4 to 5 violations occurring on property. So after the $500 or predetermined ceiling is met, we could roll back into the judicial process. This would be less staff intensive, meaning that we wouldn't have to go out on site every 2 days, but we could roll into a 14 or 21 day cycle where the fines are substantially more, right? And we'd also have some court tools to use and have that secondary piece of the puzzle. It should be really pointed out that there's an opportunity here to reduce fines. A lot of the folks that I deal with are unable or unwilling to correct nuisance violations. Mostly unable because it's expensive. It's not a free thing to fix your car, right? So those are a lot of the considerations that we take into account when we make that recommendation to the judge during the guilty finding. It's not uncommon to see 4 zeros behind a guilty finding of, you know, a significant property that's had 6 or 7 citations issued. These occur over a long period of time, but these are still regular people who have committed a civil violation, and you get 4 zeros behind a fine amount. That's kind of tough to swallow. But in the ACP process, we'd be able to go back into that and get maybe some stiffer fines, but also some a precursor to abatement or administrative warrant if needed. So the potential time to the first fine is significantly different, $50. It would do within 6 days, has a different ring than $500 in 8 weeks. The potential there, the potential consequence. So and it could add up quickly. Again, this is an on-site fluid process where officers would be out explaining and working with folks to come into compliance. This isn't a process where the city has to move forward with the full fine amount and lay that hammer down. We would be willing and open to working with folks. Doesn't go into the code enforcement budget, let me tell you. So, and again, if we were to follow a 14-day deadline for in additional fix-it tickets, our potential time to trial is 45 days. And so that would be more on-site educational opportunities with folks prior to the citation than you would otherwise see. So there's a quote from the author of the Atlantic Broken Windows Theory article, which was written in 1982. George L. Kelly once said, once you begin to deal with the small problems in neighborhoods, you begin to empower those neighborhoods. People claim their public spaces and the store owners extend their concern to what happened on the streets. Communities get strengthened. In criminology, the broken windows theory is a metaphor for disorder in neighborhoods. It states that visible signs of crime, antisocial behavior, and civil disobedience create an urban environment which encourages further crime and disorder, including serious crime. To provide a better community service, code enforcement will use ACPs to resolve individual violations when they're small stuff through community engagement and really take a house-by-house approach. As Emily Dickinson once said, if you take care of the small things, the big things take care of themselves. So I think ACPs are the much needed tiered enforcement mechanism that our program needs to be more effective and more efficient. So with that, I thank you for your time. Mark, was there anything to add?
I think you did a great job. I think Charlie back in May talked about, we really only have one tool now. It's a sledgehammer for some of these cases. And so really this ACP process is at least one other tool in the toolbox, and it's like a ball peen hammer or something a little lighter. So at least gives a little bit of flexibility. It may not be multiple tools, but two is better than one, I think, as Charlie demonstrated just in the simple photo examples.
Okay, Joe.
So I appreciate the ACP model. It's a lot of work. I can tell it's something that's new learned, and you're taking the ball and running with it, which is okay with me. And it looks like a good improvement, and I can support it, except I can't support it until I see some sort of tool in which we can separate the damage done to landlords as opposed to the violators, the behavior issues. I think it could be not easily resolved. I think it can be resolved in a fairly easy way in regards to that initial contact when you see a violation and then you post something, because quite often they're not home. I know that. I'm not saying they're always gone, but typically they're not home, especially if you have a stored vehicle or whatever. But instead of just posting on the property or in the windshield, the door or whatever, that the next action should be an absolute audit research, the property owner, and yes, you can go with registrations. Of course, probably 2/3 of your registrations nowadays are void and inaccurate and expired. But I think it's very important that you can simultaneously send a violation notice to the occupant, label it as occupant or resident, and send one to the property owner saying, be advised, we have placed, you may have seen this notice. If not, this property has been posted with the following violations. and this is the process. So that gives that landlord that heads up saying, okay, we got a problem here. I'm gonna call my renter and I'm gonna say, fix it, or I'm gonna be climbing down your throat. So it's something that's the same time notification, so that way the landlord is well aware. It's usually typically an automatic violation of the rental contract, which allows for an immediate response. But if you give them a lag of 14 to 30 days, well, that's lag time that the landlord's losing being able to do anything about it. So I think that's a huge ingredient that's missing here. And I think that it's very important that property owners know it if they're different than the occupant. That would make it, I think it'd be fair. Now, the property owners would have no excuse for not doing anything. So they can be held accountable and they have nothing to whine about. But if they are all of a sudden getting a surprise notice saying, hey, you got a court order, by the way, and it's gonna be $1,000, and if you don't pay it, we're gonna put a lien on your property, or et cetera, et cetera. That is, to me, that's completely unfair. But I can support this again, if you have some sort of mechanism that really goes to the violator and the ability for the person who's actually responsible for that property to have them being given proper notice as well.
Sure. So what I'm hearing, just to clarify, is that nothing wrong with the ACP necessarily, but a key fundamental piece that's missing is that notification, not necessarily just the responsible party, but also all parties who have standing within.
Whoever has a dog in the fight.
Yeah.
They should be notified. Whoever's got a dog in the fight and is gonna end up potentially losing anything, they should be given notice.
And that's from the very beginning is what you're
Right
saying.
from the start.
Because then they're a partner with you. They're actually a partner and they can actually help the resolution. That's what I was gonna say.
They can absolutely contact you and say, let me help, I will help you, let's meet over there or whatever, and we can figure this out, or I can I can get a tow truck in there the next 3 days. Will that work? Your response, sure. And all of a sudden it's all done. But some renters are not going to respond at all. They're going to blow up your notices and your citations, and all of a sudden now you're into it with many hours of work. You're involved in a course when that could all be avoided.
Victoria,
That was my,
Okay.
I was just agreeing with that, yeah.
then Corey.
Thank you. I appreciate this work to kind of introduce the layers or the tiers, as you say. And just listening to folks share their opinions, I'm thinking one of the things that I'm interested in, if we're going to start this in a new way, is can we collect demographic information about the process? One of my concerns or just curiosities would be our understanding if everyone, if we're striving towards some more fairness, as we say, it would be interesting to see in what neighborhoods, who is getting treated in which part of the process. So where does it get escalated? Where does it not get escalated? And see if we find that we have some bias or where there's some disparities in terms of who's being treated in what way, or, people have opinions about renters versus landlords or things like that. So if we're going to start this, and when we get to the place where we do, if we can collect that information, so we have a good understanding of, how is our code enforcement landing? And is it landing in an equitable way, or is it just another way that people are getting pushed into the system in different ways? Does that make sense?
I understand.
Yeah, thank you. Yeah, it's an opportunity for us to kind of dig in a little more. Thank you.
I was just gonna say, I completely agree with what Joe was saying, and on the flip side of that, if a landlord said, oh yeah, you can park your car here, and gave the tenant permission to do so, and it was a violation, that's just, makes the point of they should both be informed.
Sure.
Because maybe the tenant, the landlord told the tenant it's fine to park their car over here on the grass, whatever, because you got two vehicles, and then they were under the impression that that was okay and didn't know the code.
Sure. And that's a very common, issue that we deal with. And that's why notification and warnings.
They might even be paying for extra parking. Didn't know that, yeah. So.
Okay,
I could just respond to Councilor Rodley's point. It's a great point. We have had a lot of concern, primarily from our city attorney's office, about the fairness of how we receive complaints, and then it can be used as a tool for discrimination, different things. So we are keenly aware of that and want to prevent people from using us as a weapon against certain populations and that kind of thing. So.
I appreciate that. Thank you.
Okay, so I've got I guess a couple of comments about it. Like, I like the framework. I feel like we're about on conversation 2 out of about 5 conversations we're gonna have on this. The one question that I had is when you sort of separate these between sort of the ACP process and the civil process, are you expecting more, I guess, cases to come through, right? Because if we push more work into this in this quicker ACP process, we may create. Is there a concern about creating some induced demand here?
I think initially, there will be, it will be more time consuming than our current process. But I think time to resolution is going to be significantly reduced. And as we are out in the community more, we're going to have to be in the community less. So, if we go into a framework of an observation approach, where we're looking at geographic areas or we're looking at specific object violations. So we're looking at prohibited parking throughout the city or along the Main Street corridor. Those would potentially, I think, be case creations, but I don't think this will be, we're still complaint based. It's going to be a little bit more time in the field. On the, when we're getting out of the truck and talking to folks, but we're going to save that time back in the office when we have to do the administrative piece of this, where we have to draft the letters and mail it. So I think, time per violation, I think we're going to be equal.
Victoria?
Do you have, or are you looking at getting some type of software that's going to help you with the management of this so that you are seeing those properties that are maybe getting a lot more complaints than others, or that are repeat offenders, or where they're at in the stage of the process? Okay, we went and talked to them at this, it's green, and then it's yellow, and then it's red, or something like that, as opposed to just like an Excel spreadsheet.
Yeah, and so you're talking data, right, and analytics, and I think one of the big asks, probably number 2 on the list, is when we're looking at these software vendors, is we need data. We need to be able to collect this data, record it, and make it efficient. And so that's a huge piece, I think, both to Councilor Rodley's point and yours.
And even GIS based type where you can map it and see a heat map and those kind of things. I mean, Charlie has a timeline for researching all the different types of software available to really assess what fits our needs the best.
And Joe, so the numbers you used earlier today, did you say up to date for 23, you have you received 179 complaints? Is that correct? That's correct. So that's on average just a hair below 7 a week.
Yes.
So you're mentioning dealing with 10 a day. So it appears as though most all those are pre-existing, and that the 7 per week that you're getting is just on top of the 10 before they are resolved.
The majority of the complaints that we've received, I haven't done a first inspection on. I haven't been out to see them. So when you consider the total time spent as a code enforcement officer, the minority is spent in the field in the role that I'm currently serving. So I haven't been addressing 10 complaints a day or cases per day. As I said, that would be an average of what we normally see. With court and some of the municipal court matters that we've been developing the abatement process. I've been really tied up with some of those more public safety, life safety issues.
So I just kind of do the numbers and they weren't jiving very well.
Yeah.
If I could just interject too, the say 10 per day that he addressed, those are repeat time visits for multiple different cases. It's not always 10 new cases per day. He's doing these multiple site visits on, every 2 weeks or something. He's going back and
10 case management, basically, active case management, 10 a day. Okay.
Okay, so I think the other two important points is the things that constituents reach out to us are actually the hardest of the hard, right? They're not the people that are gonna go into the ACP. And what I'm looking for when we have the next conversation about it is maybe just a little bit more information about is there any tweak or streamlining, or if we talk to the judge, right, do they have any sort of ideas to sort of help us address those, those constant, those frequent flyers that are just out there in open cases for a while. It is very common for me to talk to constituents and say, hey, you're doing the right thing, right? But this thing is going to feel like it's going to take forever because these are so complex and so hard to work with.
Mayor, I don't know if we can necessarily incorporate that into the ACP timeline. I think that requires more staff on site and staff response. Well, we could look at streamlining the court procedures to citation. What we've done in the past months with a few different cases, which are chronic issues, is we've gone into the abatement process, and that has been pretty quick. So typically there's an initial, almost exclusively, these are already in our sphere. We already have an active case at these locations. If it gets to that point where we feel it's necessary to abate, 10 days before we get somebody on site is, a much quicker resolution than your typical, oh, well, we'll go cite them again and we'll cite them again in 2 weeks.
If I could just interject again really quick. So I think one of these 3, 4, 5 conversations, the next one that'll happen in the fall, we will be back to you. I think we can bring you back some ideas and discussion about that. Charlie mentions abatement. That is a new dynamic for code enforcement. We haven't really gone into that realm. If we have, it's been quite some time. He's working very closely with our finance department to look at the liens and things. So we know of properties out there right now that are probably $50,000 to $100,000 to actually do a cleanup on them. We don't have the means to do that today. He's done a couple within just the last 8 months that were pretty big, high profile cases that took a lot of doing. These are over $10,000 worth of cost to abate. But we can continue down that path and have conversations about how to make that part of the program better as well.
Yeah, and I think we all got to sort of think about this in sort of tiers, right? The first one is to get through ACP. The next one is to sort of dive into streamlining one of those. But like that, particularly those tough cases are the ones that really impact neighborhoods and just have people that are frustrated and wanting to just move because they just wanted to stop. And I think it's valuable to point out that is still an issue, even if we have to lobby for state money for additional cleanup, but like being able to clean up and deal with those kind of issues in our neighborhoods. My last question before we get wrapped up here is when I think about the, sort of code enforcement, right? I also think about those chronic properties exist sort of at a nexus between fire issues and PD, right? And probably even some public works issues, right? So again, I think the comment that I have is that really I'm looking for like an all city response, because if they're on your chronic list, there's a high probability that Chief Scheer may want to chat with them about other issues, right? So how is that going to sort of play out?
I've had conversations with both the fire marshal, which is who represents fire's response. Chief Scheer was kind enough to grant us an audience, and Lieutenant Rapay will be the point of contact there. So that meeting just needs to be scheduled.
Okay.
It really does. I think we've got Chief Worthington had a broken window task force. And we'll follow kind of that model, but I think it's more information sharing. Recently, we've started creating a hot sheet, a code enforcement hot sheet. Every couple of weeks, we'll share with staff who may be affected about several different residences, which are current issues.
Look, and I mentioned this to Nancy earlier, but like I think ECDEV has an interesting model, right? Because ECDEV and Public Works meets Friday. It's the secret Friday meeting to sort of share information. There's probably a really good model in there to sort of pull back and pursue something like that, where you're taking that same code sheet and kind of tapping the fire folks and the police folks on the shoulder and saying like, let's get connected. Maybe it could be on Thursday. So we have a Thursday meeting and a Friday meeting.
No, yeah, Friday is not.
All right,
And maybe just educate yourself a little bit on warrantless searches. On warrantless searches.
Warrantless searches. I don't want to do warrantless searches.
Oh, but you will be able to.
Possibly, I want to stay at the curtilage and stay at my.
so hang on. Okay, go, Mark.
Just to recap, it sounds like we're hearing support for moving forward with the ACP. We'll bring it back to you in the fall.
Yep, all right. I think we're good, and I'm seeing people kind of get up and stretch their legs, so I want to take advantage of their being, 10 minutes before our next meeting. So thank you, guys. We'll see you in the fall.
Thank you.
We're-
Thank you. It's not.